You want to come up too? So this is Colorado Real Estate Investing 101, and we have myself, Amy Weisbender, and Karen Collender, and we do have some new people in the room. Usually we have a lot of regulars, so we'll go ahead and kind of give our backgrounds. I've been real estate investing for over 20 years. I own 13 doors. 2 are short-term rentals and the rest are long-term rentals and across 3 different states. I started helping others buy and sell real estate about a little over 5 years ago. I was pretty passionate about, I take that back. I first thought I was going to be a professional investor. That's what I started with when I left corporate America, and then I realized helping others was way more fun. So I switched to that and doing that, and I met Karen along the way. I'll let you give your background. And we started this class almost 3 years ago.
Yeah.
So we've been doing this consistently every month, bringing in amazing vendors like Kate here today. But Karen, you want to give you a little bit of background about yourself?
Sure. So I'm Karen Callender, and in 2015, I was a teacher. So I was a Jeffco teacher for 21 years, and my husband's a teacher. And we have 4 boys, and we were like just barely, getting by every month. And so we started looking into investing in real estate, and we bought our first investment property in 2015, and then I fell in love with real estate, and so I got my license a couple years later, and been doing that now for 6 years. And then I met Amy and found out she had many investment properties, so I wanted to learn from her, and then we started this class.
Alright. I will talk about, this is Karen and I's 5 steps to successful real estate investing. And we do this class just as a give back. We want to help others continue what we're doing, but do it better and smarter than we did. We offer this education once a month. We do investor consultations. So this is a 1 hour, we sit down with you, we ask lots of silly questions, and at the end you have, what are your investing goals? Are you ready? If you're not ready, what do you need to get there? And we encourage our clients to do this with us at least once a year to kind of reset, or any life change to reset what they're targeting when they invest. We also have our investor analysis sheet. This helps you analyze a property that you currently, I have 2 different ones, one that you currently own, analyzing it on an annual basis to see how it's doing. Also one that a new purchase. So we have these free tools we give to you. If you want any of these things, you can sign up on our sheet. And then we do real estate reviews. Real estate reviews are just a high level, what's your property value, as well as what are your returns, any suggestions. If it is an investment property, any things that we see in financials, or anything that we suggest that you can do differently to make it more successful for you. So that is our free things. Here's all of our classes we have coming up, and we're gonna have to start working on our next year's schedule pretty soon.
This year is going so fast.
How is this? It's just changing randomly.
It is changing.
That's crazy. Okay.
It seems like it's okay time though.
Well, I'm not gonna get into this, but CAPI is how you make money in real estate, and I have a whole class on it coming up in 2 months, so we'll go over that then. I am going to pull up Kate's slides. You wanna introduce Karen?
Yeah, so I want to introduce you guys to Kate Silburn. Kate has been a longtime friend and legal advisor to myself and my family, and just has a heart of gold. So it's great to have a trusted legal partner on our side. So come on up, Kate.
Woohoo! That's very kind.
Hi everyone, my name's Kate Silburn. I own Rocky Mountain Elder Law, and I do comprehensive estate planning. I do guardianships, conservatorships, probate administration, and litigation. I also do a fair amount of protecting our elders from financial exploitation, so I'll touch on that as well.
And just for for the video, like you can go to the tree.
Okay, great.
You're good on the side if you want to be on the front, and just to hear a pointer like that.
Okay. So, who I am. I'm not just an attorney. I am someone who really considers my job a vocation. What I mean by that is that it's my passion. I love what I do. I care deeply about families. I represent families. Often they bring in their elders to do an estate plan, and then the 40 to 50 somethings do their estate plan, and then they have kids who are starting to have children, and I do their estate plan. So I have several families in among my clients who are three levels, 3 generations, and I love doing that work and making sure that the littles have guardians chosen and in place, and that families really begin to think about protecting their assets, protecting their wealth, and for their future generations. This is a slide, and for those of you who are on camera, we'll tell you a little bit about what I love and am passionate about. This is my husband Vince. He's a carpenter. He's worked for a company called Kelly Trucking in Golden for almost 25 years. He's a supervisor, but he builds everything that his boss can imagine, including a 55,000 square foot horse arena, and all the houses for the kids, and he does beautiful work. I wanted to put that slide up because we're passionate golfers. I'm a passionate skier. We have a son who's much larger than this now. He's 6'5", but football player, basketball player, just finished high school, and will be on to college in the fall. I put a picture of 2 dogs. I did inherit this dog from my father. He was a colonel in the Air Force. I'm deeply proud of his service. And our other dog. And these 2 pictures, I grew up in Crested Butte, Colorado, so I grew up skiing and left home at 16. Worked in the fashion business for several years, so part of what I got to do in the fashion business was do pictures of skiing a lot. I did all the Obermeyer and lots of different ski catalogs while I was working. One of the things I did also was be a double for Lady Diana. So that is not Lady Diana, that's me with a wig. So I did security detail basically for her, not on that fateful night, unfortunately, but I was a decoy in many instances, and did a lot of pictures in English Vogue and Tatler and different magazines, French Vogue, and posing as her. But my agent could never tell any of the other fashion houses that I was doing that, because then they'd all peg me as Lady Di, so I had to be covert in my work for her. So it was never in my portfolio. And then finally, I'm a passionate reader. I did, before law school, I did a Master of Divinity, so I am a hospice chaplain as well. I care deeply about end-of-life care, end-of-life choices, planning for incapacity. And one of the things that informs my life and my work is James Baldwin, one of the great American public intellectuals, so I always put his book on my slide. We can go on. Okay. So, different areas of elder law. My company is Rocky Mountain Elder Law, and people think, well, is it just for people 70 and older? Well, no. We do estate planning, like I said, for people of all ages. If you're 18 or older, you need a medical power of attorney, period. I will do it for free. That's how passionate I am about having a decision maker in place in case of an emergency. And for all those kids, like my own son, who are going off to college, All parents should have a power of attorney for their child so that they can get medical information for their child, and preferably a financial power of attorney as well, so that they can have access to all kinds of college information, financial aid information, admissions procedures, that kind of thing. They can stand in the shoes of their child, even 18 and older. So, I have this slide. I know I'm not here today to talk about financial exploitation, but it is a big part of my work. I sat on the State Board of Human Services for 8 years, and one of the things I'm most proud of in serving in that role was we passed legislation for what's called the At-Risk Adult Statute in Colorado. It's a very progressive statute. It basically targets seniors 70 and older are defined as at-risk adults. Adults with developmental disabilities or other kinds of disabilities are considered at-risk adults. And what we did was put in place criminal and civil penalties for people who take advantage of our elders. And that includes abuse and neglect, but it includes financial exploitation. So I get a lot of calls, unfortunately, of people who know of or are the victim of financial exploitation and abuse. And oftentimes, you know, since we're here and doing this today, that involves real property. So it's really important to secure your real estate assets. Unfortunately, a lot of the exploitation occurs within and among family members. That's a great sadness for me, but I fight to regain title to those properties and help our elders live comfortably for the rest of their lives. So, estate planning, it's not just a will. Please don't ever think that it's just a will or a trust. Two very important components of an estate plan, and a trust isn't always necessary, but for those of you who are thinking about investing and holding various properties, it may be a very good idea to think about a trust for your family. But a will is basically a document that doesn't come to life until you die. So a will is an important document, and you want to have one in place, definitely, but it is in a sense, a sleeping document until you pass away. A trust is not that. A trust could be something that's living while you're alive and holds assets. There are testamentary trusts that come into play by virtue of operation of a will, but the trusts that I'm going to refer to today are living trusts. They can be revocable, which means you can take back out of the trust whatever you want, when you want, or irrevocable, which means once you place items in real property or different kinds of accounts or assets, they are no longer reachable by you. So the trust always owns what's in them, but there's different kinds of trusts. There can be revocable, i.e. I can reach in and pull it back, or there can be irrevocable. Irrevocable trusts can be very important planning tools when you're contemplating long-term care, Medicaid, those kinds of costs and expenses. So irrevocable trust can also be really important when you're planning for, say for instance, a grandchild, and you know that you're not going to need that asset, but you want to preserve it for the education of a grandchild. That's also when I use them a lot.
So is for real estate, is there one that's better?
Well, it depends on what you want to use it for. But I would say that an investor would like to have maximum flexibility to take out. So a living revocable trust is more along the lines of what an investor would be interested in. We'll touch on more on trusts.
Okay.
This next document is what's called a living will, differs from a will. It covers 3 circumstances. It covers a terminal condition, a persistent vegetative state, or COVID. I call out COVID in my living will because we're still contending with COVID. Powers of attorney, super important. If you're doing a lot of investing, if you're doing a lot of financial work for your family to preserve their future, you want to make sure that there's a financial power of attorney in place. If you're ever traveling or there's an emergent circumstance where you're in the hospital and can't attend to your business, you want to have a person appointed who can. This is super important for people who invest, people who, even just someone who doesn't. Financial power of attorney can be an extremely important document so that people have the ability to stand in your shoes and attend to your affairs if needed. A medical power of attorney, we already touched on that. Probably the most important document you'll ever sign, including that of a marriage license. And I say that in all seriousness. I don't mean to demean the institution of marriage. It's super important when you sign that license, but having a medical power of attorney in case of emergency is one of the most important things you'll ever sign. In Colorado, it's particularly important because in the absence of a medical power of attorney, it's what's called a group of interested persons can decide what your medical care will be. You do not want to leave it to a committee to make decisions. You need to have a conversation with the person you appoint as your agent under your medical power of attorney and really make those wishes clear. The last wishes declaration is simply talking about burial and cremation. A dementia document, a lot of people don't do this planning. I do it because many people have fears about dementia and around dementia, the diagnosis. So this decides levels of care at different stages of dementia. HIPAA release, now with your medical power of attorney, there's tons of HIPAA language in there. So you're not gonna need necessarily a HIPAA release, but a lot of medical care providers still want one. So I always do them to make the plan complete. Declaration of guardian for adult. If you have your powers of attorney, it's unlikely you'll ever need a guardian, which is a court-appointed person who looks after your health care well-being. A conservator is someone who looks after your finances. So if you have a financial power of attorney, you don't need to go to court to get that done. But in the absence of those documents, it's really problematic and expensive to go to court and get a guardian and conservator appointed. So that's also why you want to always have your powers of attorney in place. And then for those of you with littles, anybody with children under 18 should have a declaration of guardian for their minor children. You do not want to leave it to the courts to decide who's the best person to raise your children. That is something you want to avoid. It doesn't, I'm not slamming judges. I'm not saying they can't make a good decision about who cares for your children or who would be the best person, but we want to leave it up to ourselves to make that kind of decision. So, a will lays out what you want to happen with regards to property and assets after you die. Again, a will only comes into play once you've passed away. So again, the powers of attorney are the most important documents while you're still alive. And I keep harping on that, but it's just so important that people have these in place, because what happens for me as an attorney is I get the call where it's either because of dementia or because of a terrible accident or because of something, we don't have powers of attorney, and then I'm left in a position of going to court to get a guardian or conservator to do things like pay utilities and pay the mortgage, to manage basic things because there was no one in place appointed. So, trusts. As I said before, when to use them and how. A lot of people come to me and want a trust because they want to avoid probate. They've listened to Suze Orman, they've listened to different advisors on whether it's TV or in books who say avoid probate at all costs. if we were in New York where I practiced, if we were in California, Florida, Illinois, other states, Kansas for sure, you want to have everything, including your socks, in a trust. You want to avoid probate at all costs. And the reason you want to avoid probate is because in those states, the lawyers are all tied up with the process of probate. They get a percentage of the estate in many cases. It can be very expensive and very time consuming and burdensome. In Colorado, we're extremely progressive in this area. Probate is efficient, inexpensive. We have no death tax, so it's not just a great place to live, it's a great place to die. I know that sounds really crass, but it's true. It's true. We don't have death tax here. But probate is very efficient. So that reason alone, just that reason, I want to avoid probate, is not really for me, for my purposes, to be of good counsel to you, is not reason enough to do a trust. There has to be other reasons. And one of them can be you want to avoid probate of a house. Say, for instance, I just did an estate plan for a relatively young couple, small children, but they have a very expensive house, and it's paid off. Now, the reason I say it's paid off is because some mortgagors, some lenders, do not want you to change title to your house to a trust if there's a mortgage. That can be determined to be a default under that loan. So you got to be really, really careful. Some lenders are very flexible with it, and they're okay if it's in a living trust, especially in those states that I mentioned, because everyone's doing it. But in Colorado, you have to really do your homework to make sure that you can put it in a trust. This house should be in a trust. We have little kids, so we want to make sure that asset is preserved for them by operation of that trust. So the house is titled in the trust. Kids are the beneficiaries of that trust. They're not old enough now to inherit a house under a will personally because they're just little kids. So we want to make sure that that asset is preserved and avoids probate in that instance. We want to make it as smooth as possible in terms of the transition to the kids. A different scenario, in my view, if those kids were grown. Maybe if the only asset going into the trust is the house, maybe those kids can inherit the house and either divide it or buy the other one out, or however they want to do it. Other assets that go into a trust can be, a trust can be the beneficiary of certain kinds of accounts, investment accounts. A trust can be, you can move certain kinds of accounts into the name of a trust, even checking and savings accounts. It creates an administrative step when you sign checks as trustee and those kinds of things, and trusts have to have tax returns filed, and there has to be certain kinds of steps done. But it can be an extremely effective tool for holding assets and avoiding probate, particularly if there's a lot of assets, and a lot of different kinds of assets. The one thing that I always say absolutely do a trust for is if you have real estate outside the state of Colorado. You do not want to have multiple probates running. Like, for instance, people that I just worked with have 2 properties in Florida, a lake house in Minnesota, and their primary residence in Colorado, as well as a condo in Colorado. So in that case, we absolutely want to do a trust. We want to avoid probate in Florida and in, was it Wisconsin or Minnesota? It's a lake house, somewhere up in the lake area of our country. So absolutely bring in and utilize and make a trust work for you, particularly when you have those multiple real estate holdings in various states. That can be a very efficient way to control and hold property, and then when you pass, you don't need to have multiple what are called ancillary probates running. So your primary probate would be in Colorado, but then you would have to open probate in Florida, open probate in Wisconsin. Just a really expensive and not necessary. The other situation where trusts become really useful is if you have a disabled child or even a disabled adult child. You want to segregate certain kinds of assets designated for them, and the reason you want to use trusts is because they may be receiving or going to receive a stream of benefits from the government. And we want to segregate those assets so their benefit stream isn't interrupted by a large inheritance or even a small inheritance. You can be knocked off Medicaid or disability with even a small inheritance. So we want to plan for that very carefully and make sure that that child's benefits are not interrupted.
So I'm going to drill you on some trust questions.
Mhm.
I want to really understand them. So the irrevocable is the one you can pull in and out of, right?
No, revocable.
The revocable.
Think I can
okay.
revoke. So
Revoke it. Okay.
yeah.
So that doesn't require tax returns. The other one.
no, they both do. All trusts require tax returns.
Interesting.
All trusts, there's special IRS forms. I am not a tax lawyer, but I can direct you to tax professionals who will assist you in managing your trust, but you absolutely want to stay current with those. Every trust needs to have what's called an EIN number, a tax ID number.
But the one is living now and one's not
Both.
living, or
Both
are
are.
we talking about different?
Yeah,
Okay.
both are. A testamentary trust is one that only comes to life when you die. It's by
Okay.
operation of the will.
Okay.
That's called a testamentary trust.
That's great.
But a living trust is one that's created at your estate plan. We sign it. I obtain an EIN number. We move forward with that transaction.
Okay.
Yeah.
How long does probate take in Colorado? So if someone has real estate and their heirs go through the process, what is the typical timeline of that? From the time that the person dies to the time that they can then typically do something with the property?
It depends on if all the heirs agree. If all the heirs agree,
Does that ever
it's
happen?
6 months to a year. Yes, absolutely. But in the vast majority of cases, there's not a fight.
Good.
People just want their money or their real estate. So in the vast majority of probates in Colorado, it's 6 months to a year. Some people want to move really quickly, so what you do is publish a notice to creditors. You limit the time that a creditor can come forward, because you have to notice in Colorado. Or if you decide not to notice, you have to wait a full year. But I'm a big one for publish in the local weekly little paper with Jefferson County's the Lakewood Sentinel or whatever, and get that period closed early, and then distribute. You can distribute after that period has run, and tie it up in a neat little bow.
So what would you say is the difference between, so if someone does just the will and then they go through probate and they become a personal representative and they're supposed to execute the will, right? As a personal representative, or you have a trust where you don't go to probate but the trust
As a trustee,
and they're supposed to
execute the terms of the trust.
So
But
it's
a
kind of
trust
the
can
same,
go
but
on and on. A will is finite, so a probate is finite. You can't leave money indefinitely to future heirs under a will.
Okay.
It has to be a life and being, so a born child. A trust can be very flexible. It's a very interesting type of document because it can work to really look at the heirs of your children. So my, you wanna put a percentage towards, and trusts are governed often by what's called a HEM standard, which is health, education, maintenance, and support. So you can really direct, how you want, most of the trusts that I do are often older people who have multiple assets, but their primary goal is, often their kids are professionals, so their kids aren't necessarily the bucket they want to leave it to, but they'll maybe leave 25 or half or something like that. But the wealth, they want to see their grandchildren get educated. That's a huge value in the vast majority of trust work that I do. The huge value is I would like my grandchildren to come out of university debt-free. Big value. And if they don't use that money for university, they would like it to be used for deposit on a house or for graduate school. Say, for instance, they come out of university debt-free, they would like it to pay for their primary goal often is education. So you can direct things in a way that follows that health, education, maintenance, and support. But education is broadly defined. So it could be a trade school. It could be, education is broadly defined. It could be the Cordon Bleu in Paris. You want to be a chef. It doesn't have to be Harvard. So there's lots of flexibility in maintenance and support. You can only imagine that can be widely defined. But trusts can be very, very flexible instruments in terms of deploying your wealth across the generations.
So you could even say,
Oh, no,
I've
go
been
ahead.
asking all the questions. No,
No, go
go
ahead.
with yours first. I'll remember it.
So I have a question for you. Can you set up a trust so it kind of kicks in only when you die?
Yes, that's called a testamentary trust, and it's by operation of a will.
Okay.
Yeah, and
So
that's
that-
and it's a great idea.
And that's going back to Amy's question. So like, if you set up that way, you might not have to file tax returns until that kicks in. Or is
Oh
that
yeah,
correct?
no, you don't have to because it's
Okay.
not a living entity
Right.
until you die.
And then as like does your law firm like hold, so my other question was, you're setting up a living trust where the trust is the beneficiary of all your assets, so can you maybe like hold a quitclaim deed at your law office, so when I pass away, that you then file that quitclaim deed, so it goes into the name of the trust, rather than,
I wouldn't do that.
okay,
Yeah, I wouldn't either.
I would have the trustee of the trust be directed to transfer assets. In that case, with the testamentary trust, a really smart way to do it is have the personal representative, used to be called executor of the will, also be the trustee of the trust. And direct them that all real estate shall go into the trust.
and
Any
what about
real
other
estate,
assets, like 401ks, could you just make
you
your
can
living
beneficiary
trust
them,
the
yeah.
beneficiary?
Mhm.
Okay.
Yeah.
But you recommend, so like, what if they have a mortgage and they're one of the lenders that's like, we don't want you to transfer title into the trust.
Then I would suggest waiting until that mortgage is paid, or doing a testamentary trust, because probably by the time you would pass, you being very young, would have that paid off.
Okay.
Yeah.
Okay. Thanks.
Mm-hmm.
And then, as far as that trust will define what they should do, and I've seen, I've even heard of very specific, like, I don't want you to sell the real estate for, 5 years after, and then I want,
People can get
people
very
to have
particular.
the
They
property.
can get very particular.
But what happens if that person doesn't fulfill their role?
That's called a breach of fiduciary duty. So as a fiduciary is someone who's a personal representative, used to be called executor of a will, a trustee of a trust, an agent under a power of attorney, a conservator of an estate of a living person, but they make financial decisions for them, a guardian, who does the healthcare and well-being decisions for someone, court appointed. So there's different fiduciaries. Financial planners are fiduciaries. Attorneys are fiduciaries. So when someone is a trustee and is directed by the document to do X, Y, Z and does ABC, if no one objects, no one objects. But if they do it and they're self-dealing, or they don't prudently invest, or they completely contravene the terms of the document, that's a breach of fiduciary duty, and that is a cause of action that's brought before court, the probate court, and I litigate those claims a lot on both sides. People accused of breaches of fiduciary duty and people who bring those claims.
So I think part of picking who you're putting needs to really
Very
I think
carefully
I have
done.
13 doors, right? I don't even know if my husband could manage them effectively,
Mhm.
right? Like, how do I make sure that I don't?
I would
lose my
strongly
dogs?
recommend with that kind of portfolio, a third party.
Third party. That's what. Do you have people you recommend?
Yes,
Or can you do that?
yes, and people who've handled 13 doors, who've handled 27, who've handled 100. And they're very, very good.
Is it usually a person that you?
It's a company,
Or a company. And then
because they
people
have a
then-
succession plan, right?
Okay.
It's because you don't want an individual as a third party fiduciary. You want a company so that someone, if they leave, you have a fiduciary in place, always. But yes, there's a company that I use, I know the founder. I've had many, many, many clients with this company. I just signed them on to 3 estates today.
Cause I actually, the first time I did my trust, I didn't ask people, I just picked who I wanted, and then I made an update, and I was like, maybe I should, as now I'm in real estate and I see people in that role struggling with their duties.
People really struggle.
I was like, maybe I need to ask them first if they wanna do this, cause that's
Mhm.
a lot, and that's kinda where I was wondering if it's,
And I would
don't know
strongly
how to do it.
recommend a strategic plan where you not only use them as trustee, but they're your financial power of attorney.
So you align those.
Mm-hmm.
Can you
And-
have a financial power of attorney that, so like when you're married and the finances are shared, can you have a financial power of attorney that like helps the other partner when, like if I died? and
Yes,
I had a
because
financial
I
power-
have a lot of families where within the marriage, one person handles the finances.
Mhm.
Making that other spouse in charge of large real estate is, to me, unfair
Mhm.
and a recipe for disaster. And I've seen the disasters. Surviving spouse comes into my office with a box, and
I see that.
and my wife handled everything.
Mhm.
She paid Excel. She paid everything. And he doesn't even know the password to her phone or bank accounts. And that is really a scary situation because it is not easy to get Wells Fargo to relinquish those passwords. You can get letters testamentary when you open a probate and they'll back down, but it's a long process. But with a financial power of attorney and shared information, one of the things in my estate planning binder is a list of passwords, which I recommend to do in pencil because they change. My most important thing is to do a password that is a master password that releases all your other passwords. I'm really, really serious about that. Because it can be catastrophic. And I don't say that word lightly when someone can't even get into your phone or log into your computer and you're not on automatic bill pay and something happens. It can be very, very catastrophic. Mortgages go unpaid, taxes go unpaid, people just, and it's to no fault of the surviving spouse, but can you imagine also if the person's single? Who's going to manage everything? And I have elderly parents. My son was in a catastrophic accident. He had X, Y, and Z. He has a place in Tahoe. He has a place here. He has, and we don't even know where the keys are to the house. So there's the tool called Knockbox. Knockbox, N-O-K. And you'll see ads for it on Facebook. I know that's very cheesy, but you don't have to go on Facebook to buy it. You can just go on Knockbox. And it's a banker's box size of relevant information, including copies of keys. And I say that because people don't have keys. And so it has keys to everything, safe deposit boxes, properties. It has leases if you have leases in place. It has a place for all these different kinds of documents, life insurance policies, the estate plan, everything. The Knockbox is the first thing you grab in case of fire. And that and your estate plan, and obviously the baby box, and I mean the stuff that we think of in case of fire that we're gonna grab. But I am really, you know, that kind of preparedness is something I hope none of us ever need. That's my hope and my prayer, is that none of us ever need that kind of preparedness. But the fact is that things happen, and they can happen in an instant. And to have that all set out for your loved ones is a gift beyond measure. It is absolutely a love letter to your family. Just as I always call an estate plan as a love letter to your family, because you are saying, even if I weren't here, here's how I'm taking care of you. Even if I couldn't, from a hospital bed, here's how I'm taking care of you. And you don't have to worry. This is how you access everything. This is how you'll get into everything. Particularly if you hold accounts separately or you hold them in the name of businesses and you are the sole member of that business. You know, that goes for LLCs or corporations or anything, and your spouse does not have a share of that business, or you've been filing taxes separately as married, all those kinds of things, you want to make sure that they're in the loop, even if it's something they don't want to think about. I have a husband who acts like he has an allergy if I say there's life insurance. He doesn't want to think about estate planning or anything like that. It's very, very difficult for him. But at the same time, it's something that he needs to know. You know, he needs to have a sense of security. And that is giving somebody that you love a sense of security. I truly believe that.
Lots on trust.
Okay, so we don't have to touch on living wills unless people are curious about what a living will does. Powers of attorney, we've kind of covered my passionate spiel on why this is so important. We can sort of revisit the idea of a third-party fiduciary. What would a third-party fiduciary do in terms of taking care of a spouse? Well, in the power of attorney that I do, the financial one, it talks about maintaining the lifestyle of the children, spouse, everybody, making sure, but just the great thing about a third-party fiduciary is you can educate them while you have capacity and you're present. I mean, say for instance you went for 30 days to Europe or to Japan or wherever. you can say, hey, financial power of attorney, I'm allowing you to act for the next 30 days. If anything should arise with any property, if anything happens, they're already educated. So if something final happens, if something, God forbid, you passed away, your financial power of attorney is already fluent in your assets. I mean, that's a great thing. They already know when rent's due. They already know where to go to collect it. And that's a really, to sort of educate them and get them on board while you're here, present, alive, and have capacity is, I'm a huge advocate for that. I'm working with a family in Vail who winter in Arizona, but also have a property in Hawaii, and we are getting them on board in July with this company that I recommend, and their kids are relieved. Everybody's relieved, but they don't want their kids fighting. So a third party is a really artful solution in that instance, and can manage and knows, you know, what's going on long before they have to step in. But everybody in the family knows them. Everybody in the family knows they can call them. You know, if people are receiving money, in this case, in the family, people get annual gifts. They get, you know, the agent under the power of attorney knows that this gifting should continue. All of those kinds of things.
So when you hire or set that up, then you just have to, every time you have a change, you've just got to communicate with them. Do they usually like meet with you?
That's
Every
what I
so often?
recommend. I
Okay.
mean, if you decided to go on board, I know exactly who I'd love for you to use. Her name is Karen Miller. She works for a company called Basor Christian. That's the company that I was talking about, and she is fantastic and can handle very large portfolios and can handle just the little lady with her house and needs assistance in that way, you know. But she has a great breadth of experience, and they have an attorney, you know, on staff. They have a CPA on staff. They have a tiered structure of fees so that the lowest administrative tasks are done by the lowest paid. You know, they're very fair in their fee structure, and but she can, you know, commandeer properties, and she's very comfortable with that kind of work. And so I, like I said, she just signed on to 3 matters for me today.
Okay. I'll perhaps get her information to get out to everyone who's watching as well in
Yeah.
the room.
She's fantastic. Very, very, very smart lady. Last wishes, we talked about that, burial or cremation. We can just keep, the dementia document, we touched on that, how important it is to make as many decisions as you can while you can, particularly with your care.
Yeah, I mean, well, this is a big part too. Like, there's so many people getting dementia now. You're the main.
Well, they're living longer. I think that dementia has been around for some time, but it's just that we have a population turning 65 and over. It's, you know, people call it the silver tsunami, they call it the silver tidal wave, whatever, but people just are living longer, so there's different kinds of diseases that affect people as they age. You know, a lot of people come into my office and are very afraid of that diagnosis. So I do as much planning around the potentiality of that as I can.
Well, if you're managing multiple rental properties and this happens, so this document just triggers the financial person to be part. Or
No,
is
this just
you
talks
have to-
about levels of care, what your
levels
goals
of
are.
care, okay.
Yeah,
Okay.
yeah. No, you would have to, with the financial power of attorney, I would want someone to have a neuropsychiatric evaluation But my financial power of attorney is a standing power, which means that it doesn't depend on incapacity. So as soon as you sign that, the person who's your agent, usually your spouse, has full access to whatever accounts and so forth that you have.
Can you have two at the
Yes.
same time?
Yes, you can have co-agents.
Okay.
And that can be a really artful solution to a lot of what we're talking about, to have co-agents. But I would ask, for instance, in your situation or a situation where someone has multiple properties and names their spouse and a third party, that they can act independently. Or you can word it so they act unanimously with decision making. So you can be flexible with powers of attorney. I don't do them based on incapacity because people need help with their finances long before dementia comes in into play. Long before. Finances are the first thing to get kind of muddled.
Oh, really? Before.
Long before.
Interesting.
Yeah.
Okay.
HIPAA release we talked about, in addition to the medical power of attorney, super important. Guardian. So probate we talked about in Colorado, very efficient, affordable, not something that you necessarily need to put everything in a trust, including your socks in Colorado. But we can certainly do a bill of sale that puts every piece of personal property you own into a trust. That is certainly a way to avoid any probatable asset that you might have.
And what is the document that they get for real estate to like give them like after they've been through probate? It's a letter of
Testamentary.
Okay.
Yeah, it's not actually a letter, it's just a document called letters, but it's letters testamentary, and it gives your personal representative, used to be called executor, the authority to act on behalf of your estate.
So it's the signer at that point for
Right.
everything.
Unfortunately, fights happen. We have to contend with that. Probate litigation arises when, in the vast majority of circumstances, when someone waits to do their estate plan. So there's a question as to whether they had capacity, or they were unduly influenced by a caregiver who becomes the wife in some cases, or becomes the husband. So oftentimes second marriages, if you don't have a good estate plan or a prenuptial agreement, that can be a real mess. There's definitely a propensity for probate litigation when there's no estate plan. That's when they come calling. Because
Or they can't find it.
or they can't find it, or someone found it, didn't like it, and destroyed it. I've had those cases too, where you know there was a plan, and someone didn't care for it, because they were
So
either
do you
disinherited or got a small share.
Do you keep copies of people's plans? Or
I
are they
do,
not?
but we like to have originals. I don't keep originals.
Okay.
So you have to find a safe place. Sometimes that is just the bookshelf to put the binder, and it says Rocky Mountain Elder Law. Sometimes it's a wall safe, sometimes it's a safe, sometimes it's a safe deposit box. But yes, I always keep electronic copies.
So if it was missing and someone knew it was there, they could come and get your copy, and would that be held up and, okay.
Yeah, but it's different if you have the original. You can do an informal probate. If you have just copies, it's generally a formal proceeding. It's just a few more steps, but again, in Colorado, it's not that bad. It's just a few more steps because you don't have the original.
Okay.
Yeah. Originals are important in the estate plan.
I think that'll change with this whole like,
Digitized world.
yeah.
I think as a lawyer, that with DocuSign and all of it, I think there's going to be more flexibility. But I think there's really no replacing an original will. There's certain things like an original birth certificate, original death certificate, that those things a bank is always gonna want.
I mean, we still have to cite a deed.
We still have to cite a deed.
Lenders still want ink in most lenders. Okay.
Guardianships, conservatorships, we talked about that. And so if there are any other questions, I'm happy to answer them. I'm happy to talk with people at any time. You're welcome to call my office, or be in touch.
What is the best way to reach you? To call the office instead
To
of an
call the
appointment?
office,
Okay.
and say that you saw this presentation. And you can also email me, Kate, at rockymtnelderlaw.com, rockymountainelderlaw.com, or visit my website, rockymountainelderlaw.com, and there's a link to email info@rockymountainelderlaw, and I'm happy to respond to those as well.
What's it called if you do all of those things together? Is that an estate plan?
An estate plan,
Okay.
yes.
And is the cost, do you have like a package cost, or is it really dependent on what kind of assets you have?
It depends, and it depends on if there's trust work. The basic will package for a couple is $3,500, and for an individual it's $3,000. Trust work is then hourly on top of that, and usually runs $1,000 or $2,000 more, depending on the sophistication of assets, how many assets we're moving into the trust, those kinds of things. So how many deeds are involved, those kinds of things. That's why that's hourly. And then Medicaid planning also on top of an estate plan is usually hourly, just because of what we're trying to do in terms of a spend down to prepare for long-term care, that kind of thing.
And then when you need to make updates, is that additional hourly on top of that?
Depends on how quickly on the heels of it. If it's years later, yes, there's additional, it's hourly. If it's not years later, we can talk about it and figure it out.
Okay.
Yeah.
And you can only do deeds to transfer into trust in Colorado, correct? Do you have connections with other attorneys? in the
Yes, I
states?
do. I'm a member of Wealth Council, which is an estate planning consortium of attorneys across the country who do estate planning, and we're kind of a network. So if there needs to be deeds done in Illinois, right now I have some deeds that need to be done in Illinois into a Colorado trust. We have attorneys who will help with that.
Okay.
Yeah.
Because it's not great to set your trust up and then put nothing in it, what I was told.
No, we always seed it with $10. I still do the actual $10 bill. Your trust comes to life with $10. It's very
If you're trying
important.
to avoid probate in other states and you don't put your properties into the trust, then it's no good.
Then it doesn't do you a lick of good.
No, it doesn't.
But yes,
But you do have to take them out to refinance, right? And then put them back in. You gotta do that.
Or you could keep them in. Just the lender wants to review it. So certain types of trusts are allowable, right? If they're living trusts, then they can be.
Okay.
Yep.
Yeah, some lenders are extremely flexible and understand the use and need of trust, and as a lender, they see the advantage of avoiding probate, and they see the advantage of administration of multiple properties into a trust. They get it.
Get it.
Yeah.
Interesting.
And what if you own a property with another party? Then
You both have to agree and select an entity, the name of the entity, and how you want to hold that property as I would recommend co-trustees and co-beneficiaries of the property. So if it's a 50-50, you're 50-50 beneficiaries of the trust, and you're 50-50 co-trustees. And decisions have to be made unanimously.
So a separate trust for that property to be in.
Yeah.
Can't be with your other.
So
Yeah.
then both parties come to you together to create that.
Yes, and we have to waive conflicts,
Okay.
because there's a potentiality of conflicts. I have to always think about that with the law.
Mm-hmm.
When there's people who own things like that together, we always, you know, have to look down the road. We want everything to be wonderful all the time, forever, but we just
What
want
about
to
like
make sure.
LLCs compared to like, you know, how do you?
An LLC can be a really, you know, useful vehicle, but even the assets of an LLC will have to be probated.
Yeah.
Ultimately. But you can leave your interest in an
You
LLC
just have that
in a will,
in your trust.
or in a trust or in a will. You can leave your interest in an LLC, a very effective way to pass things. The LLC just holds it outside, much like a trust, and you just say, any interest I have in XYZ limited liability company goes to my children in equal shares, or my wife 50%, my children 50% in equal shares. I just did that recently, so.
Okay.
Yeah.
That makes sense.
And then it just passes, right? You don't have to change title to anything, it just passes.
Right.
Mm-hmm.
Very effective. So I'm a big one for LLCs. If someone says, I don't wanna do a trust, I already have a trust, I don't wanna put my out-of-state properties in a trust, I say, put them in an LLC, cause that's a very effective way to transfer title. Very smooth.
What if the kids are minors? Is there a difference that would be better? between
Yeah,
those
because in my
sections?
will, I have 2 trusts that are automatic. One is for disabled people at any age, and again, that's that benefit stream we don't wanna interrupt. And then children under 21. So we definitely shield them from inheriting
'Cause they can't
large
inherit.
sums. And a lot of people change that to 25, or they change it to 24 and do, you know, tranches. So they get a third at 21, get them through college. And before then, you can use it for health, education, maintenance, and support. But in terms of principal, they can commandeer a third, then a third at 33. And I don't like to go past the 30s on leaving stuff. If your kids can't handle inheriting property at 35 or 36,
They're not gonna handle it at 50 or
At
20
50.
or whatever.
at 50, you know, I mean, just, and
I
at
guess
that
not
time,
everybody,
people
yeah.
are getting married, they're buying houses themselves, they're having children, you know, it's like, let them have the asset, you know, to do with what they will.
Time to cut the cord at that point.
Yeah, but you'd be surprised, I mean, I have families who want to save the IRA for when their children turn 65, because they want their children to have a retirement.
Interesting.
So
Hmm.
I help people title and get beneficiaries in a row, but obviously you have to deal with the company who holds the IRA and all those accounts to change all those forms. I'll help people fill them out and do them, but yeah.
In that situation, would you refer them to like a financial advisor to say like, okay, but you could set up a 401k or, you know, something?
Yeah, I have one that I really love for seniors, and I have one that I really love for younger couples. Just because you're in a different space at 40 than you are, you know, and a lot of people, they haven't planned for retirement, so he really specializes in getting things sort of together in 60 plus, and that's a different stage of life, and that's a different place you want readiness and liquidity in a way that you don't necessarily need a wand at 40.
Other questions?
Okay, well, thank you for letting me
Thank
be
you
here
so
today
much.
so much.